So welcome back and good evening to the last lecture of the series in KB3 Business Law. Yesterday we stopped at winding up procedure and we were discussing about the types of winding ups and in what circumstances that the winding up of companies can take place. And also we discussed about the general procedure, how winding up would affect a company until it is dissolved. So today I am going to take up the different forms of winding up of companies. To start with, the voluntary winding up. And yesterday I explained that voluntary winding ups can be taken when shareholders or creditors move for winding up of the company on voluntary basis. So the first area that I would like to address is in what circumstance can a company be voluntarily wound up. Under section 319 of the Companies Act, when the period, if any, that is fixed for the duration of the company by the articles of association expires, or the event, if any, occurs on the occurrence of which the articles provide that the company is to be dissolved, and the company at a general meeting has passed a resolution requiring the company to be wound up. So it is not in a case of any kind of inability for company to exist, but of course the first situation is where the articles of association has declared that at a certain point of time the company should be wound up, or in the occurrence of any event that is predetermined, predesignated by the articles of association, then when such fulfillments have been met, then in that case the company would be voluntarily wound up at a general meeting that passes a resolution in accordance with the two requirements, one of the two requirements that I mentioned, and that could be moved at this general meeting so that the company could be wound up. That is the first situation where a company can be wound up. And in the second situation, the company, where the company resolves by special resolution that such a company should be wound up. So this is the next type of a kind that where a company can be wound up by special resolution to the effect that it should be wound up. The third situation is where the company resolves by special resolution to the effect that it cannot, by reason of its liability, continues its businesses and that it is advisable to wind up. So the third situation is where the company really feels or understands that the company cannot exist anymore. So in such a situation, the creditors or the shareholders in the company may decide that it would not be able to carry on with the company's existence. So these are the three situations under section 319 that the company could be voluntarily wound up. Now, how does the winding up procedure commence? According to section 321, at the time of passing of the resolution for voluntary winding up by the company, in any of those three situations that I explained in 319 section, the commencement of a winding up process take place at the time when the resolution so passed. So in such a situation, what would be the consequences? Under section 322, the company shall from the date of commencement of the winding up, which is the date of the passing of the resolution, cease to carry on its business anymore, except so far as may be required for the beneficial winding up, and status and powers of the company remain until dissolution, that it will not engage in business activities, but it will be a virtual death of the company, but however will keep on moving just for the benefit of the winding up until the complete and final dissolution take place. Now, the procedure involved in this shareholders winding up on one hand and the creditors winding up on the other hand can be discussed in two different ways. First, let me discuss about the procedure involving shareholders voluntary winding up. In first place, the directors of the company may at a meeting of the directors make a statutory declaration to the effect that they have made a full inquiry into the affairs of the company and that they are of the opinion that the company will be able to pay its debt in full within 12 months from the date of commencement of winding up. Now, this is what I was telling yesterday, that in a voluntary winding up, you need to bring the accounts to zero, so that all the liabilities are properly settled, and you get 1 year's time to do the final balance sheet clearance in clearing and making way for the final dissolution of the company. Now, the second step would be that the company at a general meeting shall appoint thereafter one or more liquidators for the purpose of winding up the affairs and distributing the assets of the company. Now, this is different from appointment of a liquidator by the court, where in a case of a winding up by court, it is the court that appoint a liquidator, but in a shareholders voluntary winding up, it is the meeting that take place, a general meeting that take place of the company appoint the liquidators to take the proceedings forward. All the powers of the directors of the board thereafter shall cease, except so far as the company in general meeting or the liquidator sanctions the continuance of the directors. But otherwise, all the powers will be vested with the liquidators to proceed with the winding up process. Third step would be where the liquidator at any time is of the opinion that the company will not be able to pay its debt in full within the period that I first mentioned, a 1 year period, he shall forthwith summon a meeting of the creditors and shall lay before the meeting a statement of the assets and liabilities of the company, so that the creditors would get to know that the company is going to be wound up and there aren't enough assets remaining for the company to settle all its dues in full. In the event of the winding up continuing for more than 1 year, then the liquidator shall summon a general meeting of the company at the end of each of such year, if it goes for more than 2 years of course, for the date of commencement, from the date of commencement of the winding up, keep everyone, all the members and the creditors informed of the steps that the liquidator has taken with regard to the winding up process. Thereafter, as soon as the affairs of the company are fully wound up, the liquidator shall make up an account of the winding up, showing how the winding up has been conducted in a general meeting which is called for such purpose. The liquidator shall send to the registrar of companies a copy of the account, the final account, and shall make a return to him of holding of the meeting, the minutes, and of its date that the meeting was held. The registrar then, on receiving the account from the liquidator and either of the returns, shall forthwith register them, and on the expiration of 3 months from thereafter, from the date of registration of the return, the company shall be deemed to be dissolved. So, the court is not involved in such a process as long as the voluntary winding up take place in the laid down procedure of the Companies Act. And finally, the registrar of company shall present or issue the notice that the company shall be deemed to be dissolved. Now, what is the procedure involved in the other side, the creditors voluntary winding up of the company? The company shall cause a meeting of the creditors of the company to be summoned for that day, on which there is to be held the meeting at which resolution for voluntary winding up is to be proposed. So, the previous procedure that I mentioned would be followed, and subsequently, if the creditors cannot be paid in full, then of course, you open the door to the creditors to go for a creditors voluntary winding up. Directors cause a full statement of the position of the company's affairs together with a list of creditors of the company and the estimated amounts of their claims. The creditors and the company at their respective meetings thereafter may nominate a person to be the liquidator for the purpose of winding up the affairs and distributing the assets. The creditors at the meeting held may, if they think fit, appoint a committee of inspection consisting of not more than 5 persons in addition to the liquidator, so that they could investigate as to the affairs, whether the company's affairs have been properly conducted, so that the company has fallen into a situation that it cannot anymore fulfill its duty to settle all the creditors. The liquidator shall summon a general meeting of the company and a meeting of the creditors at the end of the first year from the commencement of the winding up, and each succeeding year if voluntary winding up cannot be completed within the first year's period, and shall lay before the meeting an account of his acts and dealings and of the conduct of the winding up during the preceding year. As soon as the affairs of the company are fully wound up, thereafter, the liquidator shall make up an account of the winding up, showing how the winding up has been conducted and the property of the company has been disposed of, and thereupon, so as soon as the affairs of the company are fully wound up, then the liquidator shall make up an account of the winding up, showing how the winding up has been conducted or taken place, and the property or properties of the company has been disposed of, and thereupon shall call a general meeting of the company and a meeting of the creditors for the purpose of laying the account before the meetings. And finally, the registrar, on receiving the account in respect of each meeting from the liquidator so appointed, shall forthwith register them, and on the expiration again on 3 months, like in the case of a shareholders voluntary winding up, from the date of registration thereof, the company shall be deemed to be dissolved. So, 3 years after the liquidator has deposited the particular notices and returns, the company is ceased to be or deemed to be dissolved. Now, the next category of a winding up is called the winding up by supervision of court. The difference between a winding up by the court and winding up by supervision of the court are two different things. Because in the first instance, where the court wind up a company, it is what we call, as yesterday I mentioned, a forced winding up. But here, this is a situation where the court supervises the procedure of winding up and make sure that the winding up take place in the proper manner. Now, in what circumstance that a company be wound up in this way, or in the way where the court supervise the winding up process? That is under section 351 of the Companies Act. When a company has passed a resolution for voluntary winding up, the court may make an order that the voluntary winding up shall continue, but subject to such supervision of the court. Whereas a special application has been made to the court that in a voluntary winding up, either by the shareholders or the creditors, proper supervision of the court is required, and therefore the court may intervene in supervising whether the voluntary winding up take place in the proper manner. Even though this is part of the voluntary winding up, this is a separate procedure as laid down by the Companies Act, that in an application made to the court, as I mentioned, the court will supervise the process. So, the order that the voluntary winding up shall continue, but subject to such supervision of the court, and with such liberty for creditors, contributors or others to apply to the court, and generally on such terms and conditions as the court thinks fit, the court may intervene, and make sure that it supervises the proper conduct of procedures and other formalities until the winding up take place. So, under section 353, a winding up subject to supervision of the court shall be deemed to be a winding up by the court. Now, the similarity of the first instance forced winding up by court and this supervisory winding up by the court is that in both situations, a winding up subject to the supervision of the court shall be also deemed to be a winding up by the court. Though the procedure starts as a voluntary winding up, it ends as a winding up by the court. Now, the procedure here is that the court may order appoint an additional liquidator in addition to the liquidator already appointed, as in the case of a shareholders voluntary winding up or in the case of a creditors voluntary winding up. So, there will be two liquidators that would be working in this case. One is the liquidator appointed by the court, and it follows the same procedure thereafter as the voluntary winding up, and subsequent to the steps taken, inform the court of such steps taken, and thereafter dissolve the company accordingly, as by informing the registrar of companies and taking the necessary steps by the registrar to deposit all the returns, and thereafter provide another extra 3 months for the company to be dissolved. Now, we have come to the end of the more main areas or topics of the company law in line with the Companies Act number 7 of 2007. But however, there are some specific areas that I wish to address and clarify today, especially focusing at the questions that you have received in your exam papers throughout these years. So, I have taken some important areas for much more clarification. One of these areas is the solvency test. We know that a company is deemed to be solvent. That is to mean that the company itself is engaged in its affairs in a proper manner as a normal solvent person, so that the company conducts its affairs rightly and correctly. Now, like a normal person, normal natural person, a company is deemed to be also as a juridical person or a legal person, a solvent person. That is why we do have the director board to look after the affairs of the company and do the right thing, because the company is not a natural person, though it has the legal personality. It has to be taken forward by shareholders and directors who are involved in the company. So, therefore, it is important that solvency test is carried out for a company to make sure that the company's affairs are running well. And also this is quite important for its shareholders to know that their shares are protected, their investments and capitals are protected, and also for the customers and the clients, including creditors, to know that the company is in safe hands. So, the solvency test, this area which is important to test the business viability and the sound handling of company's matters for the benefit of the company and its shareholders. Section 57 provides that the company shall deem to have satisfied the solvency test if it is able to pay its debts as they become due in the normal course of business. So, the company remains solvent as long as it is able to pay its debts as they become due in the normal course of business. And also, the value of the company's assets is greater than the value of its liabilities and the company's stated capital, so that at any given time when the company is dissolved or deemed to be dissolved, then the company is able to pay out its debts to the relevant creditors and the others who have invested their capital, the capital needed for the company. So, in doing so, the board also has a huge duty casted upon them. The board shall take into account the most recent financial statements of the company prepared in accordance with section 151 of the Act. So, that the board needs to go through the much more recent statements of accounts and financial statements of the company in order to ascertain whether the company is solvent, and also shall take into account circumstances the directors know or ought to know which affect the value of the company's assets and liabilities, that the directors are aware of the company's assets and liabilities at any given time, so that the directors have acted prudently in terming the company as solvent. And also directors may take into account a fair valuation or other method of assessing the value of assets and liabilities. It could be done physically or through the statements that are provided, but in most cases the due diligence has to be carried out by the directors by looking at both the aspects. So, this is about the solvency test. And next is the Indo management rule. What is the Indo management rule? This was laid down in the 19th century case of Royal British Bank versus Turcon, where it was held that a person dealing with a corporation has no obligation to ensure that a corporation has gone through any procedures required by its articles, bylaws, resolutions, contracts or policies to authorize a transaction or to give authority to a person purporting to act on behalf of its corporation. Which means that a third party or a client or a customer of the company does not have to be doubtful that the company affairs are being properly conducted. That is to mean that this person dealing with the company or the corporation has no obligation to ensure, which means that such a person's belief that the company is doing good is enough. He does not have to go in because of the application of the Indo-management rule that the company is conducting its affairs in the proper way. So, a person dealing with, as held in the Royal British Bank versus Turquoise, a person dealing with a corporation has no obligation to ensure that a corporation has gone through any procedures required by its articles, bylaws, resolutions, contracts or policies to authorize a transaction or to give authority to a person purporting to act on behalf of the corporation at the time when such a party dealing with the company is dealing with the company with the belief that the transactions that the company is entering with him or her are all right. So, this is the Indo-management rule. Then also there is another interesting area which is called the major transactions. What do you mean by major transactions? Now, by meaning of major and minor, we know the difference is that major transactions are huge transactions, not just day-to-day operations, but the huge transactions that the company may involve with. So, these includes the big major transactions include, as per section 185, the acquisition of an agreement to acquire, whether contingent or not, assets of a value which are greater than half the value of the assets of the company before the acquisition, which means that when the company has been acquired, the company has the assets. So, when the company is going to purchase more assets for the company, these more assets that the company is going to purchase exceed half of the value of those assets that were there at the time of acquisition of the company, then such transaction are considered major transactions, which are more than half of the value of the existing assets. The at the time of acquisition. Then the disposition of an agreement to dispose of, whether contingent or not, the whole or more than half by value of the assets of the company. The disposition, that means when the company is selling or disposing of the company assets, then if the company is disposing its assets over half or more of the value of the assets of the company, then such a transaction is called a major transaction. Then a transaction which has or is likely to have the effect of the company acquiring rights or interest or incurring obligations or liabilities of a value which is greater than half of the value of the assets before the acquisition, then even such acquisition becomes a major transaction. And finally, a transaction or series of related transactions which have the purpose or effect of substantially altering the nature of the business carried. Nature of the business. When the particular new transaction is going to cause an alteration of the normal general business of the company, then that particular transaction is known as a major transaction. So, in what circumstance a company shall not enter into major transactions? A company shall not enter into any major transaction unless such transaction is approved by special resolution. It shall not be a general resolution, but a special resolution to the effect that such a transaction what we discussed in section 185 is to take place. And also contingent or approval by special resolution is required, and also the consent to in writing by all the shareholders of the company for such major transaction. Then a transaction which the company is expressly authorized to enter into a provision in its article which was included in it at the time of company was incorporated. A transaction which the company is expressly authorized to enter into provision in its articles which was included in it at the time of the company was incorporated. So, the company shall not enter unless a company shall not enter into a major transaction unless such transaction is a transaction which the company is expressly authorized to enter into by provision in its articles of association, which was included in it at the time of the company was incorporated, not subsequent amendments. This has to be very careful that any amendment taken thereafter the incorporation into articles of association shall not be effective in this case where a major transaction is to be allowed. So, with that I would like to take you through some specific questions relating to the areas that we discuss, in addition to what we have been discussing for the last 3 days in this subject. From time to time I had been taking several questions with you, but now I would like to address some specific important questions that have even come up in your question paper. The question 1 deals with a situation where Newfoundland Enterprises Private Limited, called the NF, is a company which was incorporated in the year 2008 and has been involved in the business of importing and selling automobiles. So, if the company has been incorporated in the year 2008, you know naturally that this particular company has been incorporated under the new Act number 7 of 2007. However, due to the recent fluctuations in the automobile industry, NF, the company, has been facing grave financial problems, and in this context the shareholders and creditors of the company are concerned about the company's ability to meet its liabilities. All parties concerned are considering winding up of the company. In this context, the parties concerned have forwarded the following queries to be addressed in relation to the winding up of a company. Explain as to what is meant by a winding up of a company. So, as we discussed in this area, you may explain what a winding up means, but make sure that winding up is the starting point. As I mentioned yesterday, it finishes with the dissolution of the company. Then also second one is to list the types of winding up available for a company. We discuss several types of winding ups. That's the winding up by court, voluntary winding up by the shareholders, voluntary winding up by the creditors, and the fourth one is the winding up by the supervision of the court, which is similar to the winding up by court. Outline the key difference between voluntary winding up and a compulsory winding up. Here what is mentioned as a compulsory winding up is the forced winding up by court. I mentioned that where the court compulsorily winding up of the company on a petition or application made by one of the parties that I yesterday explained, seeking a winding up of the company. So, you have to in this case outline the key difference between each of these voluntary winding up situations, that is the shareholders winding up and the creditors winding up, with the winding up by the court compulsorily. So, which is not the supervision by court aspect, but the first winding up that we discussed as the forced winding up. In the second question, the Articles of Association forms the sole constitutional document of the company under the new Companies Act. I explained this when we were doing about Articles of Association. I said that it is the constitution of the company. For any matter, any reason, one has to look at the Articles of the Association to identify what are the do's and don'ts, what are the cans and can'ts of a company, and these may vary from company to company, even though a general style or general articles are being followed by different companies in the convenience of making or creating, constituting a company. But in certain situations, sometimes the objects may be different, the conducting of meetings would be different. So, in that case, you got to find all the details pertaining to a company in its own Articles of Association, or what we call the constitution. Therefore, it must be ensured that the business of a specific company must be conducted strictly for the objects as set out in the Articles of Association. The objects clause is the most important clause, as I mentioned, I believe, on the first day of this lecture series, and there I mentioned that you need to classify your objects very carefully. You need to include all the affairs that the company is expected to take. Generally, many companies follow the same tradition of applying a generality of objects, saying that the company can do all and sundry. But I would advise that any company should be mindful of restricting to the main and the ancillary types of objects for which the company has been formed, in order to make it simple for the company's existence rather than making it complicated. And therefore, try to be as specific and specific as to the object, so that the company's affairs are more determined at the constitution of the company. Later on, if a company needs to further its business affairs into other areas, diversify, obviously you can amend the Articles of Association appropriately, and so forth, include new objects that a company wishes to engage with the business and the affairs that it's going to get involved. So what you have been asked to do here is to say whether do you agree with this statement. Now, generally answering such a question is, in first instance, you need to give the answer as yes or no, and thereafter discuss reasons for conclusion. So, in this case, do you agree with this statement? Yes, of course, and then you can clarify, as I mentioned, the areas accordingly. The two specific questions that I did not address in my previous lectures during the last 3 days, and with the 4th day being today, I conclude my lecture now, and I wish you all the very success, all the very best in your at your exams as well as in your future endeavors and passing as a chartered accountant. Also, I wish to thank all my viewers and listeners for listening me, for viewing my lecture and listening to my lecture, and taking your time out to follow these very important tips that I gave in answering questions as well for your exam. So thank you very much again, and see you next time.